In 1974, a maintenance worker at an Ohio Whirlpool plant fell 20 feet to his death after stepping onto an unstable wire mesh screen. 9 days later, a foreman ordered Virgil Deemer and Thomas Cornwell to clean that exact same wire screen. They refused. The company response was swift. Management ordered the men to punch out, sent them home without pay, and placed written reprimands in their employment files. This specific standoff exposed a massive legal gray area. It forced a question of federal law. Can an employer fire you for refusing to perform a task that might kill you? In 1970, Congress created the Occupational Safety and Health Act. Its center is the General Duty Clause, which mandates that every employer provide a workplace free from recognized hazards. This OSHA document defines baseline protections. You can receive hazard training and file safety complaints without punishment. But standard complaints take time. Inspectors must be scheduled. When staring at a fragile screen 20 feet up, you cannot wait weeks for an investigation. Deemer and Cornwell bypassed the slow system by refusing the work immediately. The Department of Labor sued on their behalf, taking the case to the Supreme Court, which ruled unanimously in favor of the workers. The justices did not grant employees a blanket right to walk off the job. Instead, they forged a highly specific legal shield for emergencies, now known as the Whirlpool Standard. To be protected from termination, your refusal must pass a strict 5-point legal test. First, you must have asked your employer to fix the specific hazard, and they must have failed or refused to do so. Second, your refusal must be made in good faith. You must genuinely believe that the assigned task presents an imminent danger of death or serious physical injury. A clear example is an unstable dirt trench. Without proper shoring, the probability of a fatal cave-in is immediate and real. Third, your fear must meet the reasonable person standard. An objective observer looking at the situation must agree the danger is real. An observer looking at 20-foot-high scaffolding without guardrails would agree there is an objective fall hazard. Finally, points 4 and 5 require that there is no time to contact OSHA because of the urgency, and no safe alternative work is available. Failing to meet even one of these 5 criteria shifts your action from a protected refusal into fireable insubordination. The protection only activates for imminent danger. It does not cover routine slippery floors or generalized concerns about illness. Refusing to work over chronic, lower-level hazards falls outside the standard. In those cases, the law allows your employer to terminate your contract for refusing an assignment. Correctly identifying which hazard you are facing determines whether you keep your job or lose your life. If you face imminent danger, start by notifying your supervisor. Explicitly request a fix or a safer task in front of witnesses or in writing. State clearly and calmly that you won't perform that task until the hazard is corrected. Step 3 is counterintuitive. Stay at the worksite. Ask for a different assignment, but do not abandon your post unless management explicitly orders it. Following the specific sequence of behaviors is what legally separates an impulsive walkout from a protected invocation of federal safety law. Despite these laws, many employers still push back aggressively. The fear of losing a paycheck often silences workers, even when the danger is clear. However, Section 11C whistleblower claims are currently surging, and OSHA has made investigating retaliation a top enforcement priority. If you are fired or disciplined for a valid refusal, you have a strict 30-day window to file a claim. After those 30 days, your federal options for reinstatement disappear. Test this at your next safety meeting. Run through a few role-play scenarios with your crew to see if a specific hazard meets the strict 5-point test. Refusing work is always a last resort, but understanding the Whirlpool Standard ensures that when your life is on the line, you have the legal tools to defend it. If you want to know more about your rights on the job, subscribe and check out our other deep dives.